Hi, Dr. Manu. Are we going to be starting anytime soon?
Yes, I think in 2 minutes we are going to start.
Sure, no problem. Just wanted to check. Thank you.
अच्छा ये सुन इसका नाम चेंज करना नाम चेंज कर
Am I audible to everyone?
Yes, Ankita, you are audible.
Good evening, everyone. A very warm welcome to all our distinguished panelists, Honorable Vice Chancellor, Sir, Honorable Registrar, Sir, in absentia, and the esteemed faculty members of Chanakya National Law University, whose gracious presence honors this session. And a very warm welcome to all the participants, students, and scholars joining us across from the country this evening. I am Ankita Kumari, student convener, Chanakya Center for Alternative Dispute Resolution, and I have the privilege of hosting today's panel discussion on the interplay of corporate insolvency and arbitral autonomy, navigating the overlaps of IBC Amendment Act 2026 and the Arbitration Act 1996. Today's discussion engages with one of the most contested intersections in Indian commercial law, the tension between collective discipline of IBC and Arbitration and Conciliation Act. Before moving forward, I would like to formally acknowledge our three collaborating institutions. Firstly, we have India International Arbitration Center, IISC. Secondly, we have Mumbai Center for International Arbitration, MCIA. Thirdly, we have Mediate Guri Dispute Resolution Center, MDRC. We extend a heartfelt thanks to IISC, MCIA, MDRC for their partnership and support throughout the initiative of this panel discussion. I now have the honor of introducing our panelists. Mr. Naveen Kumar Singh. Sir will join shortly this session. Due to some reasons, he is joining in some time. But Sir is CEO of IISC, a legal professional of over 2 decades of distinguished experience at Supreme Court and in-house leadership. We have Ms. Vishruti Shahni, partner JSA Advocates and Solicitor, a dispute practitioner at the intersection of insolvency, arbitration, and technology regulation. We have Ms. Shruti Khanijo, partner Shardul Amarchand Mangaldas and Company, an international arbitration lawyer of distinguished standing, Cambridge alumni, and former law clerk to Chief Justice of India. Dr. Himanshu Mishra, Counsel IISc, a doctoral scholar from JNU and a key contributor to IISc's legal and capacity building initiatives. Ms. Mohana Nijhavan, Counsel Chandiyok and Mahajan, with over a decade of specialized experience in insolvency and dispute resolution, having appeared in some of the most consequential insolvency proceedings, including those of Reliance Group, Future Retail, and Videocon Industries. Mr. Vishwadeep Chakravarti, sir, independent legal practitioner with over a decade of experience in complex commercial disputes and arbitration disputes. We are truly privileged to have such an eminent panel with us this evening. I now humbly invite Dr. Rishikesh Manu sir to kindly take over the session. Thank you, sir.
Thank you, Ankita. Thank you very much. A very good evening to all our distinguished panelists, colleagues, participants, students, and everyone joining us online. On behalf of the Chanakya Center for Alternative Dispute Resolution, CNLU Patna, it gives me immense pleasure to welcome you all to today's panel discussion on the interplay of corporate insolvency, and arbitral autonomy, navigating the overlaps of the IBC Amendment Act 2026 and the Arbitration Act of 1996. It is my privilege to moderate what promises to be a very engaging and timely conversation. Now, the subject before us today brings together two important and sometimes competing philosophies of modern commercial law. Arbitration is fundamentally built upon party autonomy. Commercial parties choose their forum, their procedure, and within the framework of law, the manner in which the dispute will be resolved. Insolvency law, on the other hand, is fundamentally collective in character. Once a corporate debtor enters the insolvency resolution process, the law seeks to preserve value, protect the corporate debtor as a going concern, and bring competing claim within an orderly collective framework. Now, the difficulty arises when these two regimes meet. What happens when parties have agreed to arbitrate, but one of them enters CIRP? What happens to an arbitration that is already underway? Does it matter whether the corporate debtor is the claimant or the respondent? What happens to a disputed and unliquidated contractual claim? And what if the arbitration has practically concluded, the hearings are over, and the award is reserved, but CIRP intervenes just before the award is pronounced? So these questions require us to examine not simply which statute prevails, but something perhaps more fundamental. Where should we draw the boundary between bilateral dispute resolution and collective insolvency resolution? Now, the recent Insolvency and Bankruptcy Code Amendment Act 2026 provides a timely context in which to revisit these questions. While the insolvency architecture has evolved, the interaction between insolvency and arbitration continues to raise important questions of statutory interpretation, institutional practice, and commercial policy. And these are precisely the issues that we hope to explore today. We have with us today a truly distinguished panel representing both institutional and practitioner perspective. Since our panelists have already been formally introduced by Ankita, I will not repeat their detailed profile, but allow me to briefly acknowledge them. We are delighted to have with us Mr. Naveen Kumar Singh, Chief Executive Officer of the India International Arbitration Center. We have Dr. Himanshu Mishra, Consul IIAC. We are joined by Ms. Shruti Khanija, partner at Shardul Amarchand Mangalas and Company. We also have Ms. Vishruti Sahni, partner at JSA Advocates and Solicitors. Joining us is Mr. Viswadeep Chakravarti, advocate practicing before the Bombay High Court. And we are also delighted to have Ms. Mohna Nijavan, Consul at Chandok and Mahajan. So a very warm welcome to each of you, and thank you for joining us. Let us briefly explain how we will proceed. I will begin by putting one common question to all our panelists so that we can map the different perspective on the central issue. We will then move to a second round in which I will put a specific question to each panelist. Thereafter, I hope we can open the discussion up and encourage some disagreement or at least some healthy divergence of opinion among our panelists. We will then take questions from the audience before concluding with one final takeaway from each of our speakers. So without further delay, let us begin. So let me begin with the foundational question that we have. When CRP commences against a corporate debtor, to what extent does the moratorium under Section 14 affect pending or proposed arbitral proceedings? And viewed in light of the IBC Amendment Act 2026, does the present statutory framework provide sufficient clarity on the relationship between insolvency and arbitration? I would request each of our panelists to take approximately 4 minutes to give us their opening perspective. Ankita is whether the Mr. Singh is here or
Sir, he will be joining shortly. We can
Okay,
start
so I
with
think
other panelists.
we can start with Dr. Mishra. Dr. Himanshu Mishra, if
Yeah,
he is.
you're on mute, Mr.
You're
Dr. Mishra.
mute, yeah.
Now I'm audible.
Yes, please.
Okay. So thank you, Dr. Manu. First of all, I really want to thank ADR Society, Chanakya Center for ADR, CNLU Patna for inviting me, and also India International Arbitration Center for giving this opportunity to be part of this esteemed panel. And just to let you know that sir is will be joining within 1 or 2 minutes. I just had a word with him. And with regard to the section 14 of the code, so far I read that the position is still the same, that it is still limits the arbitration proceedings. And the way I see it is that though both the laws, whether that is the insolvency procedure or the arbitral process, they are in a way for facilitating the business atmosphere, improving the ease of business, but the modus and juncture of their proceeding is altogether different. Insolvency comes into play when things go south, and there are possibility of multiple proceedings. So for eliminating the multiple proceedings and securing the interest of securing the assets of the debtor and also the creditor, the insolvency takes in place. Whereas the arbitration is different when there are contractual obligations, there are contracts, commercial contracts, and the conditions needs to be enforced, the claim and counterclaim needs to be filed, then the uh, arbitration proceedings comes into play. So the position still remains. Even after the amendment, the moratorium still applies on the arbitration proceedings. Sir has joined, so this question can also be we can take the opinion of sir.
Thanks, Himanshu. So I completely agree with your view. So I have nothing further to add. So I think after amendment also that position, whatever was there prior to 2026 amendment, it is still, it will apply in my view. Yeah, thank you.
Okay, thank you, sir, for your perspective. Now, I think if you have Shruti Khanija.
Hi, thanks, Dr. Manu. Hi, everyone. Hi. I think this is a fairly simple looking question, but it's also got a lot more nuance in it. So I'm just going to start with the fact that something that Himanshu also said earlier. What is the purpose of moratorium? The structural purpose of moratorium is for us to look at it very purposively. Now, when I look at IBC, IBC is a very specific legislation. It's not very old. It's about, in fact, 10 years old. It completed 10 years this year. One main purpose of IBC was that anything that falls under insolvency and bankruptcy, that would be dealt with exclusively by the IBC under its own umbrella by specialized tribunals that are constituted, called the National Company Law Tribunals. Also, when we look at National Company Law Tribunals as well, they sit as adjudicating authorities and not just the tribunals when it comes to IBC. So even when with respect to NCLTs, when it comes to IBC matters, they are still classified as adjudicating authorities. So that distinction clearly reflects that IBC was always supposed to be a specialized legislation. Now, when we look at this question of how 2026 Act really interfaces with the arbitration mechanisms, again, another purpose that we need to look at is arbitration resolves commercial disputes, right? And insolvency is a very inherent structural part of how businesses function. So these two laws cannot really operate in silos. Before we look at our act and our amendment act, particularly for IBC, I just want to put perspective from other jurisdictions. When we look at other jurisdictions like the UK, the US, in fact, even Singapore, a lot of these jurisdictions utilize arbitration as a mechanism to close particularly insolvency disputes under their own statutes. But unfortunately, that's not the situation in our country because we don't consider insolvency an arbitrable subject matter. So for us, when it comes to insolvency, we deal with different issues as compared to other jurisdictions. Now, coming back to your the core of your question, Dr. Manu, when we look at the Amendment Act, what has it done? It's not that the provision for or insight within the legislators of what arbitration mechanisms can look like when a moratorium is imposed. Section 14 does contemplate arbitration panel. It in fact includes it. There were judgments earlier in which whether a Section 8, which is filing before the court to oust an arbitration, to oust a matter to arbitration, existed or not, the courts have dealt with this question and they have said, yes, you can file a Section 8. A Section 8 is a procedural ground and not a substantive ground. So therefore, a moratorium can be applicable overall, but a Section 8 will be exempted, which means procedural law questions that relate to arbitration will be exempted. And that was the position before 2026 amendment. Now, when we talk about am I audible?
Yes, yes.
Yeah, okay, great. So when we talk about the 2026 amendment, it really does not change the position, as Dr. Mishra had said, and also Naveen sir had also said. It does not change much position. It defines, it does not include what we call arbitration proceedings specifically. It does not give clarity from legislative perspective of what has changed. What amendment does do is extend the moratorium's reach in one specific direction. It closes the gap between the sureties and the guarantors who might seek to pursue proceedings against a corporate debtor under a contract of guarantee. Now, contracts of guarantee have always been very contentious. This is a targeted fixed. It's not a very comprehensive reform in terms of moratorium scope versus arbitration, which has been the crux of discussion overall. I can give you an example in an international scenario where, let's say, a construction company with heavy operations in Middle East is present, is from India. We looked at and we were representing at that time the respondent who had debt and arbitral awards against this particular entity. This entity was under insolvency and then further liquidation. The arbitration proceedings stretching to millions of dollars in the Middle East were still ongoing. And there was a very clear counterclaim as well. But when you look at it from the perspective of international or complex disputes, our law does not allow for that proceeding to finally fructify, or at the time those proceedings have not fructified, to be able to make a claim which is actually quantifiable. So to that extent, the present legislation does not resolve it, even though there are provisions of cross-border, bankruptcies. We do not still consider these issues in the whole waterfall of creditors at the present moment. So I think there is some thought that needs to go into it. And these are problems which are yet to be fixed from a purely legislation perspective. It remains to be seen how the rules will really come up and how how IBBI really takes it forward and judiciary interprets these in the context of cross-border insolvencies. Thank you.
Thank you, Ms. Shruti Khanija. Ms. Vishruti Sahni, we have already heard some different ways of approaching Section 14. Where would you position yourself in this whole debate?
I think I think Shruti, like you said, Shruti set out the ground very well, and as has Dr. Mishra and Mr. Naveen. I think one of the most critical nuances that come in to determine insolvency and arbitration, and I won't go into the background because Shruti set out that base very well for the panel, is the concept of in rem versus in personam. And that's the time, or that's the Lakshman Rekha, as one would call it, on where you actually flip, right? So, I mean, fundamentally, if you just look at it, while of course they can't exist in silos and there are two very coexistent regimes, there is a very significant and nuanced distinction between the two. Section 14 ends up pausing a proceeding, right? And when we come later into the discussion, we'll talk about how Section 31(6) has changed, which extinguishes the claim, right? And that's what 2026 has brought in. But the difference comes in, and the question was, what happens when moratorium kicks in or a company goes into CIRP when there is an ongoing arbitration? When there is an ongoing arbitration, it's also important for you to understand what it means by CIRP kicking in. It doesn't mean an application under Section 9 or a Section 7 being filed. In India, once an application for initiation of CIRP is filed, it's filed in the NCLT. That takes a long period of time. I mean, it's not supposed to anymore, but unfortunately, it still does take a significant period of time. That whole period is not a period where the company is admitted into CIRP. That is a period where the company is still trying to contest its going into CIRP. And during that period, your arbitration is not affected in any way. Till then, it is a fight in personam. It is a fight between the applicant and it is a fight between the company. Till then, it is protected. It is when the admission order is passed and the company is then, by an order of the NCLT, admitted into CIRP, is when moratorium kicks in. And that's the Lakshman Rekha that tips over, where it is no longer an in personam dispute. It is not a private dispute between the applicant and the corporate debtor. And it becomes a problem in rem, which means it becomes a problem for the world at large. All the companies, all the creditors, all the stakeholders of that corporate debtor now start getting affected because that company has now gone into CIRP. It has gone into a resolution or an overall restructuring of the company. So, to go back to your question as to where I position myself to say that I think very often moratorium is being seen as the death of an arbitration claim. It isn't. It's a pause to an arbitration claim. The death of the arbitration claim will come in when there is an extinguishment of the claim at a resolution plan stage. It is possible that it gets settled. The CIRP gets settled, the CIRP gets withdrawn at a Section 12A stage, and possibly the arbitration resumes from the stage at which it was paused. So I think I'll leave that to set the tone so that we can discuss this in further detail. But that's where I position myself, where I don't see it as the moratorium as a death of the arbitration. I see it as a pause at that stage at least.
Okay, thank you, Ms. Sahni. That's add another important dimension. Now I would like to ask Mr. Vishwadeep Chakravarti. Do you think the existing jurisprudential distinction give tribunals and practitioners enough guidance? Mr. Chakravarti.
Hi, Dr. Manu, thank you so much for having me and thank you for that introduction. Thanks, Ankita, as well. One, of course, it's a pleasure to speak here, and two, it's a pleasure to also speak after these people have already spoken, so I can almost get away by saying I agree with whatever they have said. See, the issue is, I feel personally, the amendment in 2026, which takes away the discretion of NCLTs from admitting or declining to admit such petitions, is in fact quite a blow to the confidence that the legislature as well as us have in the adjudicating authorities. Because by removing the distinction from may to shall, you're effectively taking away a large part of the discretion from the adjudicating authority. One is that. Number two is, so far as your jurisprudence is concerned, the distinction to admit or not admit, even after taking in the shall instead of may, will remain to a large extent because it still has to find whether there's a default or not, right? Even though the distinction and the scope of default has been reduced, the interplay between the Arbitration Act and the IBC will continue because the way we look at, the inherent adjudicatory process of an arbitration and the inherent in rem proceeding under IBC, that will remain. The jurisprudence, unfortunately, Dr. Manu, the way it has evolved and the way the need for legislative amendments have been there in the past, it will have to be seen in the future what kind of interpretations the court takes. Because personally speaking, and I know I'm going out on a limb, the way the amendment has been worded, I have a feeling that it could land up in courts. I mean, the way things are being challenged every now and then, it will land up in court in some form or the other. As the earlier speakers have said, it is an extremely nuanced way of looking at things, especially the distinction between the arbitration and IBC. But so far as the total comprehensive look at the amendment is concerned, I believe past jurisprudence may or may not really have an impact on the interpretation of the amendment. That's what I would like to say. Because jurisprudence, by the very meaning of jurisprudence, the problem is it always evolves. And the way this amendment has come in, by changing it from may to shall, yet not changing the distinction or the definition of a default or the definition of a debt, it's going to be definitely is going to be decided by the courts. It is not going to be decided in parliament. It is not going to end at this. That much I can certainly say.
Thank you very much, Mr. Chakravarti. And finally, Ms. Nijavan, may I invite you to give us your opening perspective, particularly from the standpoint of a party whose contractual claim has not yet been adjudicated when insolvency intervenes.
Thank you so much, Mr. Manu. Am I audible?
Yes, yes.
I think all of my co-panelists have covered your question beautifully. There's not much for me to add. But going back to the question, I think there's a unanimous consensus that there's no change from the pre-2026 amendment to this one. In fact, in my view, I think they may have fortified, because there are some additional powers that the RP has now been given to determine the value of the claims also that are put forth to him. And with such specific amendments to the other sections, there is no specific change in this regard to Section 14. Section 14 right now is as it is. It covers arbitration panels also, like we've already discussed. So it has to, like we've all discussed, it will have to be seen how courts are interpreted. And there have been various judgments. In fact, there's a very recent judgment of March 2026 where Supreme Court, in an RP-initiated arbitration, has allowed set-off. It has said that counterclaims may not be allowed, but set-off may be allowed. So saying that there's a lot to be interpreted around that area, and we'll have to see.
Okay, this is important. I think, thank you to all our panelists. Even from the opening round, I think we can identify some important fault lines. First, whether moratorium affects the arbitration as a process or primarily proceedings that operate against the corporate debtor. One more, I think, issue that has come up is to need to distinguish between the adjudication of liability on one hand and the recovery or enforcement on the other. So, with that, we have come to the end of the first round. Now, coming to the individual questions that we have for our guests, our speakers. First question, I will invite Mr. Naveen Kumar Singh. Mr. Singh, let me begin with the institutional perspective. Suppose CIRP commences against a party which, while an arbitration is already underway, and the tribunal has been constituted, the institutional fees have been paid, and the procedural timelines are running. Now, from an arbitral institution's perspective, how should such a situation be managed in practice? Should institution rules expressly address insolvency triggered stays or suspensions, or is this better left to the tribunal to determine under the applicable insolvency law and the law of the seat? What is your take on this?
So thanks, Dr. Himanshu. So insofar as that what in the first round of question, one thing is clear that insofar as that arbitration proceeding is concerned, that is a private adjudicatory mechanism between the two parties. IBC is a public adjudicatory mechanism that it is like a rights and rate. So in case when the suppose IBC this initiated during that arbitration proceeding and moratorium kicks in that situation that arbitration will there will be a stay in that arbitration insofar as that proceeding against that corporate debtor is concerned, whereas that arbitration proceeding by the corporate debtor that can continue, even the RP can continue that particular proceeding. So this India International that our conduct of arbitration regulation, IAC conduct of arbitration regulation, though It does not specifically talks about that CIRP triggered that arbitration proceeding, whereas it talks about in case suppose arbitration proceeding is settled or disposed of without hearing. In that situation, how that fee will be collected, or so what it provides that in that situation, that fee, whatever the arbitrator fee as well as the institution fee is concerned, that can be taken, it will be decided by the registrar on pro rata basis. And if any excess fee is there, that can be returned to the party. Since that earlier in our earlier round of questions, it was clearly, I think it was pointed out by Vishruti that it is basically a moratorium. What it does, it is a pause to that arbitration proceeding. There may be a possibility that that CRP, that it may be settled in between and that proceeding may be dropped. So in that situation, arbitration proceeding can continue. Otherwise, suppose if that arbitration proceeding is going is stopped and that is against that corporate debtor, in that situation, whatever that provisions of IBC Act is there, that will be applicable, and that claim need to be filed before the RP. And whatever that is, if the resolution plan is successful, then that whatever the claim is there, that will be extinguished insofar as that claim against that corporate debtor is concerned. Whereas the claim by the corporate debtors is concerned, that arbitration proceeding can continue, and that fee and whatever the deposit what the institution has taken, that can be dealt by provisions like our rule 36 subclause 8 and 9 that specifically deals with this thing, though not the CRP thing, but this type of situation can be dealt by this. So I don't think that there is any need for a specific CRP related provisions need to be put in the institution rule. Otherwise, that existing rules can cover all these aspects. Thank you.
Okay, thank you, Mr. Singh. Let me carry the institutional concern into the statutory question. So my next question will be to Ms. Vishruti Sahni. Ms. Sahni, section 14(1)(a), it refers broadly to the institution or continuation of suits or proceedings against the corporate debtor, but it does not expressly set out a comprehensive arbitration specific regime. Now, in light of the recent amendment to the section 14, how should we understand the present scope of the moratorium in relation to arbitration? And has the legislature missed an opportunity to provide a greater clarity?
I would say that uh, I actually would want to question the premise of the question itself, because I wonder if we have all been spending a lot of time asking the question about the Section 14 moratorium. We've been asking the wrong questions, or we've been asking a question that has actually been in black and white from the very beginning. 14(1)(a) uses has referred to an arbitration panel, right? It does talk about it. It does talk about the fact that it is something that is covered within its scope. 14 goes to the extent of, actually going beyond and even talking about what happens to DRT proceedings, right? So it has tried to outline what the legislation could have envisaged are the multiple other forums in which a commercial dispute or a commercial issue could have come in. The question on whether it's a missed opportunity by the legislation, I think that this isn't where they needed to focus. I feel like the position on 14 has been sufficiently taken care of. I feel even jurisprudentially, it has evolved in a manner that it actually is rather clear. It is only the creativity of lawyers like all of us on the panel who try and twist and turn it because it sometimes doesn't, serve the purpose that we would like it to. But I do think that if your question is that does the Section 14 moratorium stay the proceedings and whether the lack of too much happening on it with the amendments do us harm, I don't think so. I feel like what is there currently is sufficient. The lacunas in it have already been addressed by judicial determinants. I feel like the slight tweaks that happened even prior to 2026 did take care of a little bit of the confusion on DRT, on arbitration, and I do feel that it's sufficiently addressed. While I know that may not be your question, I will still take the liberty of going forward to talk about what it does do for us from what the amendment does do in our favor or does do in favor of this particular regime. When it comes to Section 31, right? I think the three-layered structure that actually now that has come in on the arbitration and insolvency framework actually makes and gives in a lot more clarity. The three-layered structure, which I mean may not be visible to the naked eye, but I mean a lot of us practitioners now see is that till admission your arbitration is alive. At admission your arbitration is paused. Post admission at a liquidity, and I'm not talking about liquidation, I'm talking about resolution plan, your arbitration is dead, right? It's an extinguishment. In liquidation, I would see it as a continuation of your CIRP because eventually, I mean, it's either going to get sold or dissolved. So I feel like by bringing in that clarity at a resolution plan stage of clarifying the extinguishment, which was clarified for whatever it's worth by Electrosteel and other judgments previously, but by the legislation codifying it, they have brought in the clarity to say what happens at what stage of a CIRP, pre-CIRP, during CIRP, and post-CIRP. And to that extent, I think the legislation has done a good job in being able to introduce this amendment to bring in this amount of clarity. Again, I would say that it was, I think, clear to some of us practitioners. To the extent that it was convenient to us, it was clear to us. Till it was not convenient, we would go to court and say that the law is very unclear and, argue and debate about it. But the clarity that it has brought in does help arbitrations and also institutions a lot, right? Because the institutions now don't need to wonder and worry about, oh, what do we do about an arbitration which is in CIRP? They know that when it is in CIRP, it is still paused. We still hold on to that docket. We still hold on to that file. It is when the resolution plan gets approved or the company gets dissolved is when we actually close that docket. So I do feel like while the legislation in 2026 didn't do enough, or some people say it didn't do enough, I differ with that view. In 14, I feel what it did indirectly in 31 lend a lot of clarity to what an arbitration does through the lifespan of a CIRP, or what happens to an arbitration through the lifespan of a CIRP.
Okay, so may I push that distinction a little further? Should the answer depend principally on who is bringing the claim or on the substantive effect that the continuation of the arbitration would have on the insolvency state?
So yes, there is a distinction that lies there, and you're right about that. The distinction that I would assume you're talking about is whether it is an arbitration against the corporate debtor or it is an arbitration initiated by the corporate debtor. And that distinction becomes important because yes, you're right. That nuance comes into play during the pendency of an arbitration, during the pendency of a CIRP as well. So if there is a company that is a corporate debtor, it's now admitted into CIRP, and it is an arbitration that they had initiated for a certain amount of money recovered to come back into the corporate debtor. That continues to survive, and that continues to survive for the reason of what the basic principle or ethos of a moratorium of a CIRP is. It is to safeguard the estate of the corporate debtor. It is to ensure that all the money and value that the corporate debtor itself has is maximized and is protected. So all of its stakeholders and creditors are given their due at the stage of distribution, whichever version of it is. So yes, there is a nuance that comes in there for when an arbitration is initiated by the corporate debtor, the ability for an RP or a resolution professional to follow through and continue to that extent, as long as it can justify to its COC and all of its stakeholders that this is for the benefit and to add value back into the corporate debtor.
Thank you. So that brings us naturally to what happened when arbitration and insolvency remedies are invoked at roughly the same time. Now, the next question is to Ms. Shruti Khanija. Ms. Khanija
Apologies
suppose
for interrupting. Excuse me, sir. Actually,
is
Shruti ma'am had to drop off due to some urgent work. We can continue with the other esteemed
okay,
panelists.
no problem. So I think now we'll move to Ms. Mohna Nijavan. Ms. Nijavan, suppose a creditor has disputed an unliquidated contractual claim covered by an arbitration agreement, and CIRP commences before that claim has been adjudicated or quantified. Now, how should that creditor navigate the insolvency process? Can or should the arbitral process still have a role in determining the underlying liability and quantum, while the insolvency framework governs the treatment and recovery of that claim?
Thank you for your question, Dr. Manu. So there's no provision even in the amended IBC, which will explicitly say that arbitration has been replaced for specifically disputed or unquantified claims. But let's answer your question one by one. Let's go to the pre-2026 code. Even then, the definition of claim there said right of payment or right of remedy of breach of contract, which gives you the right to have for payment in cases of a disputed, fixed, secured, unsecured. So the very fact that a claim may not have quantified at the stage when the CIRP of the corporate debtor has been initiated was very well taken into account even pre 2026. So that position has always been very clear. If a creditor has a claim, irrespective of how much of it is quantified or how much of it is disputed, it has to be submitted to the IRP at that stage. So that clears the first answer that it doesn't really have to be quantified. Now, coming forth, we've all discussed Section 14 at length. Section 14 clearly bars all initiation, continuation of all proceedings. We have ample judgments, Hotel Godawan and all, where you've said that if you continue arbitrations despite a CIRP, that is non-est, void. So if you read it together, even pre 2026, I think the position was very clear. Irrespective of whether your claim being disputed, unquantified in your view, please submit it to the IRP. That's the first leg. Now, coming forth to what the amendments have specifically done. There's a specific right which I was talking about earlier, which has now been given to the IRP that if required, he may also determine the value of the claims. Now, you'll have to read this specific amendment and addition in light of the earlier situation. So earlier, he was not given this right. The intention of the legislature here seems very clear in this that let's give more powers to the IRP or the RP, as the case may be, to quantify the claim. Otherwise, there's no point of adding the word determination and value unless you want to give the such powers to the IRP. So I think that's also a step which clarifies that if you are a creditor and you see that the corporate debtor has been forced into CIRP, please submit your claims. The other thing is addition to Section 31, which I think Vishruti had briefly mentioned. So that also clearly now says that once a plan is approved by the NCLT, there cannot be any proceedings that can be initiated for assessment of claims. Now, if you see it separately, an arbitration is exactly that. Arbitration is submission of claims, counterclaims, statement of defense. So what you're going to an arbitration panel for is assessment of your claims. And while amended IBC may not have said that as explicitly, but I think if you read it cohesively, the intention is very clear that please submit your claims. You will have to be subject to CIRP. Now, also, like I was mentioning, there are recent judgments before our 2026 amendment got the presidential assent, where Supreme Court has recently said that for an arbitration that was initiated by the RP, like we all have discussed, that a corporate debtor can still initiate through the RP. That is still permissible under the law. A counterclaim cannot be made. So where the RP initiated such a process and the counterclaim was not allowed to be pursued, while the counterclaim they said was specifically it can be extinguished. But since the RP always knew of the set-off point that the counterparty had raised in the arbitration proceedings, and he could have probably added it to the IM or got the resolution applicant to incorporate it into the plan, and all of that was not done. So the set-off may be allowed. So the other party can claim the set-off, not the counterclaim. Obviously, Supreme Court it has been clarified that that's in the facts of the cases. So we'll have to see how it's basically done. But in my view, the position to any of my clients or a creditor, I think it's very clear. Submit your claims as soon as you find out about that. Let the RP quantify. You can always challenge the quantification amount. But once your claims are extinguished because you did not submit them at all, you may not have any remedy left.
Thank you, Ms. Mona. But don't you think there is a practical difficulty here? Now, CRP is deliberately time-bound, whereas an arbitration determining liability and quantum may take considerable a longer time. So, can the insolvency process realistically wait for the arbitration?
My view is slightly different, Dr. Manu. I think arbitrations can span over a long, long time. And the purpose of getting insolvency laws when IBC came in, you see the preamble. It's time, there's a specific time limit given. At least the intention is very clear that this process is concluded timely. And even the other amendments where you say that NCLTs have now been given strict timelines and they have to give reasons for delay if an order is not being passed. I think probably for someone, IBC may be much faster than arbitration. Because arbitration, you will have to get it assessed, then you will have to get it enforced, there will be challenges. And practically, I think anyone who's been out there in courts, they know that arbitration will take much, much, much longer than an average. I think the recent study says that we've come down to some 578 odd days for conclusion of a CIRP. So, I personally feel that maybe IBC might be just better for a claimant.
Okay, thank you very much. So that leads to the distinction between adjudication and recovery. Now, the next question is to Mr. Biswadeep Chakravarti. Mr. Chakravarti, Indian jurisprudence, again coming to the jurisprudential aspect, has attempted to distinguish between the proceeding that interfere with the collective insolvency process and proceeding concerned primarily with adjudicating contractual rights and liabilities. Now, in your view, is that distinction workable in context of arbitration? And following the 2026 amendment, is there still sufficient room for arbitral tribunal to adjudicate the contractual disputes without interfering with the objective of CIRP?
There is a distinction, Dr. Manu, between arbitration and insolvency, right? Let's take it step by step. The moment you invoke arbitration, and after that the company is put into a CIRP or arbitration process, correct? That is completely suspended. So there is no further proceeding that can take place under arbitration if it is against the corporate debtor which was put into CIRP. Once the CIRP's process is concluded, then your claim can either be extinguished, or if the company goes into liquidation, then the moratorium continues. Now, the point here is, firstly, to answer your question, I think the distinction still continues. The amendment does not do anything to, blur the distinction. I think we are reading too much into the negative parts of the amendment. The amendment has not done really so much as to, other than that, to reduce the timeline for an adjudicant authority to admit a claim. Now, the problem there, as always, and I'm sorry, Dr. Manu, I'm always answering your questions. Both your questions have been on jurisprudence, and I, as a lawyer, I have the luxury of saying it depends on each fact and circumstance. Because jurisprudence is like in fact, the draft questionnaire that your team circulated also says that the courts were divided on even the issue of a Section 8 application, right? The problem that we see today is not a question of whether the courts are unable to distinguish or the jurisprudence is problematic when it comes to an adjudicatory process or something that resembles an in rem remedy. The problem is that the adjudicating authorities are not consistent in their approach. Now, I firmly believe, of course, On a holistic level, putting a timeline is always a good thing. Like Ms. Nijavan rightly said, the whole preamble of the IBC was with a view to restrict the timelines. As Justice Narimanan said, it is a debtor's paradise. The debtor's paradise, the idea was to change that. Because in India, a claim or an arbitration can extend well beyond the statutory timelines. The problem here is, however, how are you going to conclude or to control the quality or the consistency of, like you said, sir, jurisprudence? How are you going to control the consistency of the decisions, especially now with such a short timeline given on the NCLTs? Right? The idea behind, like I said in my opening remarks, I personally feel that the amendment with respect to changing from may to shall is going to have a negative impact going forward, at least in the short run. My view may be myopic, but definitely in the short run, there will be a lot of jurisprudence from both sides because the timeline is so short that it is not enough for adjudicant authorities, especially the way they are functioning today. Because at the end of the day, you have to look at adjudicating authorities across the country, not only in Bombay and Delhi, right? Where there is a wealth of jurisprudence that is always given by each party, and each party has at least 5 to 7 lawyers being presenting each case and lots of judgments being put in front. The idea is, I feel that this is putting the cart before the horse. The focus on the amendment, again, sir, just to answer the jurisprudence point, was not to shorten the timeline. The focus has to be on training and has to be on the consistency of the output and the outlook given by all the NCLTs across the country. Not simply by reducing the timeline are you going to get to a desired result. Yes, on a holistic level, of course, you have to have a limited timeline between which it should be done. But by removing the discretion, I think it's caused more confusion than otherwise. That's what I feel on the jurisprudence. Yes, of course, the distinction between adjudicatory and the insolvency and the in rem proceedings will always continue. That is not going to go anywhere because that goes to the very root of the two proceedings. And the amendment cannot ever take that away. That's my view.
Okay, thanks, Mr. Chakrabarti. Now, one thing I was just curious to know. So, suppose if you have to formulate a clear test for courts and tribunals, where would you draw the line between adjudication of a claim and enforcement or recovery of that claim?
No, I think more than a distinction between the two, quite often one view that can be taken is adjudication is a necessary prerequisite to enforcing a claim. Correct? Now, the idea behind the Insolvency and Bankruptcy Code as well as the amendment is to carve out a certain aspect of claims or a financial debt, right? Where there is no foreseeable or any prima facie dispute, where a default has obviously taken place, where the company has to be admitted. Now, this is precisely what I was saying earlier, Dr. Ma, that this discretion is a cardinal part of the insolvency proceedings. By putting a strict timeline and by making it shall from May, you are taking away this discretion. So because the idea behind this is, it is not my opinion of the case or yours for that matter, right? It is the opinion of the adjudicating authority which is deciding whether or not to admit a case, whether or not to see whether this is an in rem proceeding or an in person, whether a default is regularly there or whether a dispute is actually there. That discretion, I feel, should not have been taken away by removing it from may to shall. Timeline, yes, I completely understand. But this is something that I feel personally is going to land up in courts.
Okay, thank you very much, Vishwadeep Chakravarti. Now, let me now take the problem to its most extreme factual point. So my next question will be to Dr. Himanshu Mishra. Dr. Mishra, let me give you a difficult hypothetical situation. Now, the arbitral tribunal has been constituted, evidence is concluded, final arguments have been heard, the award is reserved. And then, before the award is pronounced, CIRP commences against the respondent. Now, what should the tribunal do? Can it proceed to pronounce the award with enforcement remaining subject to the moratorium, or must the arbitral process itself come to a halt? And So the recent amendment that post 2026 framework, whether it gives a clear answer to that. Sir, you are not, you are, please unmute yourself first.
Am I audible, Dr. Manu?
Yes, yes.
So the way I see this problem, the answer can be in two ways. First, with regard to the statutory provisions of the IBC, that is, there will be a moratorium. And initially, there were many conflicting views of NCLT that one view said that yes, award can be passed, the other view said no. Then in electro steel, somewhat this position crystallized, and it was clearly outlined that the award gets nullified. And the tribunal, the arbitral tribunal may have power to declare the award, but the effect of the award gets nullified. So, reading of section 14 gives us very clear viewpoint, as it was pointed out that it gives stage-wise procedures that at what stage what will happen. So even the passing of award is also a part of arbitral proceedings. For taking a reference from a different point of view, that is the Arbitration Act, if we refer section 32, it says that the arbitral proceedings shall terminate at the passing of the final award. So the award in itself is a part of a proceeding, and as the proceedings gets stopped, in the very same way, the passing award also needs to be stopped. So my position and answer would be that yes, tribunal should refrain from passing of the award because of the moratorium.
Let me make the hypothetical even harder. Now, suppose the award has already been signed by all three arbitrators, but has not been formally delivered to the parties when CRP commences. So would your answer change in that situation?
Yes, in that situation, even if the award has been signed and the information of the award has not been communicated to the parties, then this would be a probable outcome. And again, that this is a very ambiguous term because this particular juncture has not been defined. No one, even the legislature or we have not seen these kind of situation. So maybe as it has been observed, the way the jurisprudence will evolve, we would be able to find the question to this precise point that once, but my position is that so far the communication has been not made. The award is still with the arbitrators. They have it. They might have signed it. They have it. It should be stopped.
Okay, thank you, Dr. Himanshu. So we have come to the end of this individual question session. Now, coming to the next part, it will be a cross-panel discussion. Already we have examined this issue from several perspectives. All the eminent speakers have given their point of view. Now, let me put one broader proposition before you. Whenever arbitral autonomy comes into genuine conflict with the collective objective of insolvency resolution, the latter should ordinarily prevail. But outside that zone of genuine conflict, arbitration should be allowed to continue. Is that a workable principle for harmonizing the Arbitration Act and the IBC? So, who would like to take the proposition first?
Can you just repeat the proposition, sir? I did not actually understand.
The broader proposition before this panel is whenever arbitral autonomy comes into genuine conflict with the collective objectives of insolvency resolution, the latter should ordinarily it should prevail. But outside that zone of genuine conflict, arbitration should be allowed to continue. Is that a workable principle for harmonizing the Arbitration Act and the IBC? So that was the proposition, and I would like to the panelists to take up this in between.
Just to give my 2 cents to this, I think that should be allowed. If you see IBC even under section 14, bars recovery. There are ample judgments here which allow assessment. So if it has to be a harmonization, probably you can let the tribunal continue assessment. In fact, that assessment may indeed help the RP also at the time of quantification of the claim. And probably at the stage of recovery, that can be stopped because then that will be directly in conflict with each other. Because you have separate recovery proceedings or enforcement and execution proceedings under the Arbitration Act. And the process of recovery, essentially, we don't call it recovery definitely, but of getting the money under the resolution plan is slightly different. So probably that, and some of the jurisdictions globally do accept it. So probably our legislature could, but sadly there's no such amendment right now in place, could consider this to continue with the assessment and stop the recovery so that they're not constantly in conflict with each other at that time. So that's my 2 cents about it.
Okay, thank you. So does anyone on the panel disagree with that formulation?
I
Yes.
don't disagree. Sorry, I don't disagree, but so in principle I agree, and I agree for a bunch of reasons, which maybe I'll park because you've not asked my view on that. But I do want to be honest that the strongest argument against the proposition is that a blanket rule is a little cheap to administer, right? A tailored rule is more expensive. If the NCLT today has to decide case by case whether the arbitration genuinely conflicts with the collective process, you have created a satellite of a dispute in a 330-day process. And the parties who benefit most from this sort of a satellite dispute are the ones who have the deepest pockets in a case like this. So again, going back to the fact that in principle, I do agree that I do agree with the proposition, and I do think that it is a workable harmonizing solution. I do feel that the trade is not really autonomy versus collectivity. It is, precision over speed, if I can say. And unfortunately or fortunately, at some point in 2016, our parliament chose speed. And I think they did it deliberately because of the issue that they were trying to tackle. So I'm not sure. I mean, I again, in principle, I think Mohana and I are coming from the same place because I think as practitioners, there is that it serves both of us well. If
Yes.
today we can pursue arbitrations which don't get stopped just because an IBC has come in, so it's not good for business, this proposition at all. But I wonder if we go into the thin line of reading into it with the IBC, how far we'll be able to stretch it.
I think a useful middle ground could be interim measures. I think, like you rightly said, like both Mr. Javan and Ms. Sani, like you said, it's difficult to see from case to case what the ultimate purpose of an arbitration proceeding is, especially at an admission stage of a CIRP. But a useful middle ground, what I feel, is that interim measures which go towards protection of the subject matter of the arbitration, those could be carved out definitely from the law.
But how would that play out, right? Like if interim measures are putting some sort of imposition on properties or assets of a
Correct.
company under moratorium, then you're technically interfering with
With the
something that is
moratorium.
actually, you're interfering with
No,
the moratorium.
the idea is, yes, you're absolutely right, and that is one example for sure. But when it comes to an assets which have been a part of the estate of the corporate debtor, and one of those assets is subject matter of, let's say, a Section 9 proceeding or whatever it is, when it comes to preserving the asset itself, I feel some kind of a middle ground can be taken where even an interim measure, which has to be taken in the teeth of, let's say, dissipation, right? That also comes to a standstill the moment a CIRP is ended. And a CIRP and the IBC process is something that is completely very different from an arbitration proceeding. In a Section 9, you may possibly get a relief much before the IBC proceeding.
I know, but the thing is that's where I think the conflict between recovery and like insolvency
Precisely,
comes in,
if
right?
you are asking for, go on, please.
No, because Section 9, and I'm talking about Section 9 under the Arbitration Act, would be in pursuance or in furtherance of recovery. Whereas the premise of an insolvency claim is that it is a crystallized debt already.
Yes.
And therefore, there is no need for that specific asset in arbitration to actually be in any way interfered with, because the presumption of your claim under IBC is that it is already crystallized. And I mean, I know this is again me going beyond it, but the question that, was previously also put to Dr. Mishra regarding pronouncement. And we've actually had this debate in another panel that that should possibly be a carve out, because if in the pronouncement it turns out that the arbitrator has crystallized that debt can then form a part of the claim in the IBC. So it should be a pronouncement because it's at the stage, the adjudication is done. The corporate debt is no longer getting affected by the arbitrator, by any section 9s, by anything else. It is just a crystallization, and to find out whether the arbitrator has crystallized that as a debt or not. So if the pronouncement was allowed, and it was a debt that was crystallized in favor of the applicant, he could have gone in, just like Mona and we both advise our clients regularly to file all claims, irrespective of what it is. At least that person can go and file that claim, and then the RP can do whatever he wants with it. He wants to allow it, not allow it, verify it, not verify it. So I guess maybe to that extent, I differ on that view on the Section 9 IBC continuing, but I also differ on the view that I feel that pronouncement should actually be allowed at such a stage.
Sorry, I meant to say Section 9 in arbitration.
Sorry?
Yeah, that's
Section 9. Yeah, Section 9 arbitration.
Oh, okay.
And just to also add, because if you do have a crystallized debt at the stage of pronouncement, your recovery effectively in arbitration might be slower than in IBC.
True.
So if you do have a specific number in place, if you see, instead of going by 34, 36, 37, God knows what all, and we know, I mean, unlike high courts, these days at least NCLTs have started giving a much shorter date. So you might be able to recover it much sooner.
Recovery, there is no dispute. Absolutely.
So for the stage of pronouncement that we were discussing, that at that stage, definitely there could be a carve out specifically, because like Vishwati pointed out, it's not going to affect much now. It's right at the fag end where only an order has to be passed. And for all you know, the order has been almost written also.
So my view is little different. Basically, that actually this IBC and arbitration both operate in the different uh, prism. So, like arbitration, it is a private dispute between the two parties, whereas the IBC is initiated when the corporate debtor is unable to pay his debt. Then this IBC proceeding is initiated, whether the company should be liquidated or it should be that resolution process can be, after the successful resolution process, it can be again start afresh as a new company. That thing is. So harmonizing both this proceeding, that arbitration, as well as this IBC, I think there will be a lot of practical difficulties with respect of the jurisprudence in which both this act has been enacted. So it cannot be that IBC, because sometimes many a times that arbitration proceeding is initiated by one party, whereas that insolvency proceeding has been initiated by the separate set of people. So whatever the moratorium and all this thing, because once that public remedy is invoked, that will prevail over the private adjudicating process. So in that situation, it cannot be, because it is not going to serve any purpose when the public remedy is continuing. At the same time, you allow that separate arbitration proceeding to continue. So it is not ultimately what will happen. Suppose after spending that lot of time and money, whatever the award is there, and that award, that his company is not having any that much assets to for the realization of that award, or if that claimants fail to file their claim before the RP, that whatever is claim in that arbitration adjudication is there, that will be extinguished. So I think that IBC proceeding will continue. The arbitration has to wait for this thing. This is my take.
And just to add to the point of a sir, there can also be procedural difficulties. Let's say at what juncture this exception needs to be carved out, whether that the stage of reserving of award or whatever that juncture be. That might again create a multiple rounds of litigation. So the problem is that even if this execution is exception is carved out, its operationalization will be really difficult. So that's why even so long the award is not in the public domain, has not been communicated, is within the domain of the arbitrators, it will be difficult for it to be get passed if the moratorium takes place.
I have just one question to ask, just from a practical. I want to just know something. So in case whether CRP has been admitted, right? And once the CRP has been admitted and there is a moratorium and so forth, in case, and I have an arbitration clause in a contract where I feel that and a dispute has arisen, and the asset I feel genuinely is in threat of dissipation, what remedy do I have then?
You have only remedy to file your claim before that RP.
Claim is for recovery, sir. Claim is not for preservation of asset. I'm asking for asset preservation.
No, so far that asset preservation is concerned, once the IBC kicks in, all that asset is the duty of RP to preserve all that assets. The company cannot sell any this thing till the time this resolution plan is not approved. So whatever things is there now, it is in the control of the public body like RP, and he will take care of this thing. Insofar as the individual party claims are concerned, he has no remedy. He has to file his claim before the RP, and it is the duty of RP to see. Yeah.
No, okay. So for example, what you're saying is, sir, once the CIRP is admitted, the RP has an ongoing, everlasting duty to maintain the estate of the debtor. Yes. Now, if I have a apprehension that an asset is being dissipated, do you say that I have no statutory remedy against that other than to be under the belief
insofar
that the RP is...
Yes, insofar as the individual claim is concerned, you have a remedy to file your claim before the RP.
That is for claim, sir. I am not asking for claim. I am asking for preservation of the asset.
Sir, for preservation of asset, for what purpose? For realization of
for
your
example,
claim
if I have funded a particular machine or an asset that has been purchased, right? And if the corporate debtor is doing something that is destroying or reducing the value of the asset, right? If I have an urgent need to preserve the status of the asset, are you saying there is no statutory remedy to do that? Other than to simply write a letter to the RP and say that please
yes, because the once RP is appointed, that claim is admitted under this thing, RP is appointed, he will take over the management of the company. So now the company is in his effective control, and it is the duty of the RP not to do anything to harm the assets of the company. So insofar as your thing is concerned, what is, because suppose you have supplied a machinery to a particular company. So what is your claim is there to, you want that, suppose that money is due, outstanding of that particular this thing, so that your claim is of that particular money. So you can file your claim before that RP, and RP, after seeing that entire thing, he will see that suppose if resolution plan is successful, then whatever the proportion you are able to get, that much only you will be able to get this thing. Otherwise, you cannot initiate a separate proceeding for preservation of this assets. Otherwise, it will be this multiplicity of litigation, this and this, all this adjudicatory process. All. Suppose if you are going to the courts and all. That's why that moratorium procedure and all these things, that all the proceedings, everything will stop during that particular 180 days, and this RP has to. There will be a single door, single window. This thing for all everything.
I'm just going to rephrase that. If I think preservation is something lawyers just say nicely to basically say that can I monetize from that particular asset? So if the true question was actually because you were concerned about preservation, then preservation is now the IRP's problem. It's his job. It's under 18, an obligation he has to preserve that asset. If the concern is coming from a point that today can you take over that asset and monetize from it either by selling it or by using it, you have, to be honest, in realistic terms, lost that right to do so till whatever happens in the moratorium, unless it gets settled, but it goes either into liquidation, gets sold for its parts, or it goes to the resolution applicant, and whatever happens to that asset, how it's being treated. So I'm saying that because we've often dealt with a lot of people saying, our machinery is lying there, वो तो lease पे है, वो उनकी नहीं है, it's not actually owned by the corporate debtor. Can't we just pull that portion back out of the moratorium? And my answer to everyone is, your asset is gone now. And the thing is, it was never your asset because it was an asset on which you possibly had a charge, or you had a right, or you had a lien, or you had some sort of contractual right. If it is an asset owned by the corporate debtor, it is now within the realm, control, and obligations of the IRP. You are not getting any recovery or any monetization out of that particular asset.
And just one more thing to add to this. If you're trying to take your asset, then basically you're trying to keep a carve out for yourself as a creditor, which IBC does not permit at all. Once the CIRP starts, all creditors are now subject to the CIRP proceedings. And it's only at the stage of Section 53 where you have distinctions, who has security, what charge. And now, I mean, with the amendments, that's gotten a little more academic for all of us to read on the basis of valuation. And I can see Vishruti smiling that it's going to be a task.
It's uphill task because lawyers hate numbers and you just keep adding
Yes.
more and more math for all of us to do. Like if you give me more valuations to deal with, it's the death
Yes.
of the
I think valuers are going to have a gala time now.
I know.
So
Feel there for
valuers.
them.
No, they've been having a gala time
Yes.
since 2016.
No, now it's going to be
Yeah.
because 53 and 30 have been nuanced to such extents that, especially that lower off test and all, and what's going to happen to the charges. I think the valuation might just start even before, at the stage of lending now to see where you're going to in case. But that's a completely different discussion. Sorry for changing the topic. But coming back, I mean, you can't exceptionally just carve out for one creditor. That's anyways against the code provisions. You can't give any preference to your recovery over the recovery of all others. And whatever asset it is, it now belongs to the entire pool, even if it's some money lying in an FD account. It's as simple as that. It's for all the creditors to be used and not for one person to say that I want to take care of this current account. That's just to add from my side.
Okay, thank you. I think this has brought some genuine different perspectives. Let us now open the discussion to our audience. We have received some questions, and given the time available, I will try to take as many as possible. Ankita, can you ask the audience to? Yes.
Yes. Can we have a hand raise for the questions? We will one by one let people unmute themselves.
Yes, Adit, you can unmute yourself and ask the question, please, in brief.
Good evening, everyone. Aditya this side from third year. There was one approach taken by the Delhi High Court where actually they had allowed arbitration during the insolvency proceeding, stating that if the arbitration is the benefit of the corporate debtor, it can be continued. Now, my question is, can it not create a loophole where any arbitration proceeding, as long as is it a benefit of the corporate debtor, is allowed, but where the other party wanted that we at a disadvantaged position since owing to this principle, no award can be passed at all against CD itself. I hope that I'm clear.
I'm happy to take that up, but I think what I understand is that it was a case where the CD itself had initiated the arbitration, and therefore that would have been allowed to continue, and that happens on a regular basis because the law permits it. So if the corporate debtor itself has initiated an arbitration proceeding, that is allowed to continue through the CIRP process because it is for the recovery of money into the corporate debtor, as opposed to proceedings where the corporate debtor is the respondent and they will have to release certain monies from their company. So it won't put it at a disadvantage stage because here the idea is that everything that is happening for the benefit and value maximization of the corporate debtor. So if they recover, then the money comes back into it. I don't know if I've been able to answer your question, and any of the other panelists can make it clearer, but the distinction is who files the arbitration, and that's what the determining line is, or whether it can continue or not.
Sure, ma'am. Thank you. To be specific, the judgment is Power Grid Corporation from the Delhi High
Yeah.
Court.
Yes,
Yeah,
of
that's
course. Yeah.
PGCR versus Jyoti Structures. I think that's
Yeah,
what
Jyoti structures. It's a very it's
landmark
highlight
case.
in that issue, but it does, and that reaffirms the position that we were discussing earlier, that in that case too it was the corporate debtor who had initiated the arbitration, and it was for recoveries of monies into the corporate debtor.
Sure, ma'am. Thanks a lot.
Yes, Dev.
Good evening, everyone. Am I audible?
Yes, please ask your question.
Yes. Greetings to the panel. So my question would be to Vishruti ma'am, that we have seen that IBC and the entire ADR thing is designed to eliminate procedure delay. Much like the laws gradually moved beyond the technical objections such as the stamp duty controversy in arbitration. However, after the concerns highlighted in the SL Info project case and also in the very recent Pooja Ramesh Singh versus Jammu and Jammu and Kashmir Banking Limited. In this case, we have seen that the Supreme Court has highlighted there was some hallucinated AI generated cases because of which the entire judgment was like went through and it was overruled. So, do you foresee this as a new category of a dilatory tactic emerging when a losing party routinely alleges AI dilatory tactics research to enforce a re-verification of an award or an order? Do you think that this is a tactic that might be used in the future, that these certain things are AI generated and this should be again reassessed by the court just to like delay the entire process, which is against the entire ideology that was meant for the IBC and the arbitration?
Um, I mean, I don't really know how to answer that question, but see, if it is hallucinated content, or if it is hallucinated judgments or jurisprudence that is being relied upon, then I don't think it's dilatory. I do think it goes to a root concern of how the judiciary is operating. If there are judges that are relying on judgments that are, created and don't exist in law, then I don't think it's dilatory as much as it is concerning and is more of an infrastructural overhaul requirement. So to answer your question, I don't think it's dilatory. I think it's a genuine concern. And if I today find that there is judgments or case laws or jurisprudence or provisions that are hallucinated and possibly generated wrongly by AI, I would take it up, dilatory or not, to my benefit or to my disadvantage, because I do think that it goes to the root of integrity and our faith and credibility of our judiciary. And I do think that it's something that, it should be taken seriously and shouldn't be written off as just being dilatory of one party to another.
But ma'am, as a follow-up to that question, I would just like to ask that can that be used as one tactic to delay the entire proceeding? For example, if even if I know that the entire proceeding is going against me, can I go to the court and just ask the court to reaffirm that if all the cases are like properly cited and properly and not AI generated or hallucinated, just to like stretch away this entire process for my concern?
That's only if you can establish that anything that has already been relied upon is AI generated or hallucinated, right? You have to have some basis. The court is not going to just at your whim want to re-adjudicate or reassess or review certain judgments, orders, or procedures. You are going to have to give them a credible basis to do so. And you have to give them credible doubt as to whether the jurisprudence, the case laws, or the provisions are wrongly relied on. And if you have credible basis to be able to tell the judicial tell the bench about it, then I don't think it's dilatory. Then I do think it's genuine, and it's grounds for concern and should be interfered.
Alright. Thank you, ma'am.
Okay, Ankita, do we have time to take a few more questions?
Sir, we just have one question from a practitioner in the industry. I think we can take up one more. That question is to Vishruti ma'am. When you say moratorium period is a pause to arbitration, what are the scenarios when arbitration proceeding can be resumed when the IBC proceedings are ongoing?
When the IBC proceedings are ongoing, no. I mean, it can only be resumed. I mean, I'll defer to the rest of the panelists if they have any other situation in mind. But in my experience, it only resumes if the CIRP gets settled and withdrawn under Section 12A. Because what happens is that the CIRP is commenced, admission happens. Then at some stage, the party is settled, the corporate debtor is able to pay off its debts, and the CIRP is withdrawn by an application under 12A. And in that case, I know of arbitrations that have been resumed. So in my experience, that seems to be the only one particular circumstance in which it can happen. But again, that's not a circumstance in which the CIRPs continue. The CIRP has been withdrawn and no longer exists. But I'll defer to other practitioners on the panel if they have any other examples or circumstances in which they've seen an arbitration resume.
I also
Yeah.
can't actually think of it like that. Apart from the one that I recently, Ojas Energy, where they've allowed the arbitration proceedings to continue, but that was an RP initiated arbitration, and the counterclaim was told to be extinguished. So, obviously, the policy idea behind this is that in case there is a plan or a successful conclusion of the CIRP, whatever's not part of the plan gets extinguished. So if that extinguished thing is not happening, then probably you may have any situation where you can argue out that my claim essentially did not get extinguished. So I do have a remedy left to pursue that claim at a later stage.
Yeah.
But I also can't think of any other situation apart from the fact that there's a withdrawal under 12A.
Okay, thank you. I think we have paucity of time, so I will just allow one more question from Janvi. Janvi, please unmute yourself.
Good evening, panelists. Am I audible?
Yes, please ask question.
My question is that what are the statutory safeguards that should exist?
Janvi, you're not audible, please.
I'm saying that what statutory safeguards should exist to prevent the parties from actually misusing the arbitration just so as to delay the insolvency resolution, or vice versa, say using insolvency to defeat the genuine arbitral claims.
Okay, any of the panelists would like to take this question?
I think that all this procedural safeguard is there. So it is not that if suppose IBC is initiated, so this arbitration proceeding is that like suppose IBC is initiated against that corporate debtor, that is a serious issue. And insofar as the arbitration proceeding is concerned, that is a separate private that between the two parties. So once that public remedy is there, it automatically stayed. So I think that safeguard is there. I don't think that further any more thing is required.
Okay, thank you. Yes. Thank
No,
you,
I
everyone.
agree. I feel like there is this statutory framework does have its own safeguards already incorporated in it. And till the time the CIRP is not admitted and it's only a Section 9 or a Section 7 pending, there's no bar on both of them continuing at the same time. So there can be a Section 9 IBC and a Section 9 arbitration going on in parallel till the Section 9 IBC gets admitted. So to that extent, at the point at which the safeguard needs to kick in at admission is already well captured and codified in the law.
On a lighter note, Vishruti, now before you get a listing in the Section 9 arbitration, you're probably a Section 9 IBC will now be admitted.
If only, I don't know how.
No, I mean, it says now, that's the point. No, the problem is they've made it shall now.
I mean, we can argue on that at length. I actually think it's a solid addition and like a very solid positive addition to the act. Unrealistic. The 14-year deadline is unrealistic, but it always has been. So I guess we've lived with
That's
it
why it was
for
May.
10 years.
That's why the idea was to do it May. Because it was unrealistic, and you do it with an idea to finish it within 14 days. But you see, you record your reasons for the delay. Now it's shall. Now you wait and watch how every NCLT takes a different view on this.
That's also, I mean,
Lo-
all of us saw what happened with Vidarbha,
Yeah,
with the
yes,
slight use
I
of may
agree.
and what promoters and it wreaked havoc for some time for all of us. So, I mean, I completely agree with Shruti that I think shared.
Sorry,
Sorry, I
we
was just
lost
saying, yeah,
you.
I was just saying, I agree with you that chat is a positive change. It's definitely, I think it's a good step. And as we all know, 14 days is it's just academic. It's not going to happen. 14 days to a certain dead default is not going to happen for sure. But as regards the safeguards, especially for OCs, we anyways have a carve out for a demand notice and to challenge it for
Right.
an arbitration. So,
Yeah.
I mean, that's a good safeguard in place already. Section 9 can't be initiated at all in IBC when I say that. If you can say that there's an arbitration proceeding pending, an arbitration proceeding starts even at the slight notice of arbitration. So, like all the others said, I think there are ample safeguards already in place within the code for this.
I can assure you, Dr. Manu, that there can be a full another round of panel discussion on the shall and may of the act. And I can assure you that that's at least a 1 hour long conversation with multiple people having different views. So we'll park it for then.
We will definitely have one more session on this. So we are approaching the end of our discussion, but before we conclude, I would like to ask each of our panelists for one final takeaway. And I promise this is the most difficult question of the evening because I am going to ask you just to answer in 30 seconds. So, if you could recommend just one change, legislative, judicial, or institutional, to bring greater clarity to the relationship between insolvency and arbitration in India, what would it be? So, Mr. Singh, may I begin with you?
Um, right now, I'm not able to think of this because I just put that googly. So insofar as that one change, basically that insofar as arbitration is concerned, we need to promote that institutional arbitration, and so that and other thing insofar as that this insolvency proceeding is concerned, like operational creditors and all on those things, that mediation we can try before because suppose a disputed claim is concerned. So that time can be allowed till the time that arbitration or mediation is settled. Then only that it should be crystallized as a debt and then default. So that clarity, it can be bring some statutory framework so that clarity will be there. Otherwise, on the basis of jurisprudence, that it is being practiced, but not with the clarity in a statutory framework.
Okay, sir. Dr. Himanshu?
So, from my side, first of all, it needs to be understood that both these statutes have different objectives. That's why a lot of distinction emerges between both the things, and arbitrator remains in the private realm, and insolvency goes in a kind of public realm. So, one of the suggestion would be if the legislator they want to carve out some junctures where some space can be provided for the arbitration to go on, then the proceedings can be defined. Maybe the proceedings can be defined in the act so that giving a way for forward actions.
Okay. Ms. Vishruti Sahni?
Mhm. I think my response to this is going to be that there should be limited judicial interference and intervention. I feel like the position on the interplay of the two is very clear. Um, by the jurisprudence that exists as of date, by the legislation that exists as of date, with all the amendments coming in. And I do feel like there should be limited judicial intervention and limited judicial interference in the position that now seems to have clarity, because it's courts that fall prey to a lot of creativity of lawyers coming up with nuanced arguments. And I think they should hold their ground and not fall prey to it by creating an exception or carving out an exception on certain facts and circumstances. Supreme Court should not go overboard on its 142 powers and create an exception for one particular set of facts. I think the law is clear. The jurisprudence has now become rather clear. And I think courts should stop creating those exceptions to make things, to not complicate things any further.
Thank you very much. Mr. Biswadeep Chakravarti.
We can't hear you.
Mr. Chakravarti, if you could unmute yourself. Okay. My friend, I think he's not here. So, in the last, Ms.
No, I
Mona.
think he's here. I think
He's
he's
here,
here,
yeah.
but
I
there is
just don't
some,
think we
yeah,
can
there's
hear
some
him.
issue.
Okay, okay. So in the meantime, we can request Ms. Mohana Nijavan.
I think everybody's almost covered it, but I completely agree that there should be very limited judicial interference because that's where the problem lies. There, the code is very clear in itself. It's a recent act. It's and the judicial precedents also in this regard are very clear. But recently, with Article 142's playing around, there are judgments that are passed with one line towards the end saying that this applies to facts of this specific case. But those are then misused in some form or the other, and there's confusion created around it. So I think whatever we have for now, which is codified, should be stuck to so that it becomes easier even for creditors in that because otherwise the creditor is also confused where to go, how to get, and all of it is just benefiting us lawyers because then we advise, okay, fine, why don't you try the other route, kuch nahi hota, we'll figure it out right up to the Supreme Court. So from a very client centric approach, I think, and against lawyers billing, I think that's absolutely right that there should be limited interference with the law in place today.
Okay, thank you very much. Vishwadeep, can you hear me?
Am I audible?
Yes, yes, please.
Now
Go
you
ahead.
are, yeah.
I am going to probably incur the wrath of all my co-panelists and ask for a carve out for interim measures. Maybe I will be the only one looking at billings here, but I would still stick to my earlier answer and ask for a carve out for some form of interim billings under arbitration. That's the only way I can co-harmoniously read the two statutes. The way it looks now, it doesn't work.
Okay, thank you very much. That brings to the conclusion of what has been an extremely enriching discussion. If there is one thing that today's conversation has demonstrated, it is that the relationship between insolvency and arbitration cannot be reduced to the simple question of which statute prevails. The more difficult question is where the boundaries should be drawn. Our discussion today has taken us through the scope of Section 14 moratorium, the distinction between adjudication and enforcement, disputed and unliquidated claims, institutional challenges, the timing and stage of arbitral proceedings, and the broader question of whether greater legislative clarity is required. On behalf of the Chanakya Center for Alternative Dispute Resolution and Chanakya National Law University, Patna, I extend my sincere gratitude to all our distinguished panelists for sharing their time, experience, and insights with us. I also thank everyone who joined us today and particularly those who contributed through their questions. It has been my privilege to moderate this discussion. Thank you very much, and I now hand over the floor back to Ankita for the formal vote of thanks.
I invite Priyanshu Lucky for the vote of thanks, Editor-in-Chief, Chanakya Ccadr.
Good evening, everyone. I, Priyanshu Lucky, on behalf of the Chanakya Center for Alternative Dispute Resolution, would like to thank everyone who made today's session possible. I would like to start by thanking Dr. Rishikesh Manu, Director of CCADR, for moderating the discussion and setting up the key issues. I thank our panelists, Mr. Naveen Kumar Singh, CEO, India International Arbitration Center, Ms. Shruti Khanijo, partner at Shardul Amarchand Mangal Das and Co., Ms. Vishruti Sahani, partner at JSA Advocates and Solicitors, Ms. Mohana Nijavan, Counsel, Chandyok and Mahajan, Dr. Himanshu Misra, Counsel, India International Arbitration Center, and Mr. Biswadeep Chakravarti, Advocate, Bombay High Court, for taking out the crucial time to provide their expertise. We covered a lot of ground today. The existing tension between the IBC moratorium and arbitral proceedings, the changes brought by the 2026 amendment, and the practical questions around administering stayed arbitrations, including institutional clauses, treatment of escrowed funds, and reconstitution of tribunals. I also thank our partner institutions, Mumbai Center for International Arbitration, India International Arbitration Center, and Mediate Guru for their continued support. I would like to thank the whole CCADR team for making this panel discussion a successful event. Finally, I thank the audience for joining and making this discussion engaging with your questions. Thank you all once again.
Thank you. Thank you for having us. Have a good evening.
Thanks. Thank you.
Thank you very
everyone.
much.
Thank you. Bye-bye.
Thanks all. Thank you.
Thank you.